better to speak with a few notes rather than run a PPT. So good afternoon, friends. It's not the right time to talk on this subject, particularly because you are in a rice-eating community. You're all members of the rice-eating society. So you know what happens when you have rice, whether it is white rice or boiled rice. At about this time, the starch factory is working and you tend to drowse a bit. But that's okay. I'll forgive you. Now, this topic is very interesting because I've been at it for the last 33 years. I trained as a lawyer first. My journey as a lawyer has been quite funny because in the first year of law, I got the first rank. Second year, I got the second rank. And third year, I got the third rank. That happened because between the first year and the second year, I finished my CA intermediate with the 55th rank. So now I knew that I was going to pass the final. So I stopped pressing the accelerator. But my first love was always law. So I started practice, but I was not so encouraged by the attitude of the then income tax officers whom you had to bribe. And I don't compromise on bribing. So therefore, I decided to pursue alternative dispute redressals. In the earlier days, we did not have much to do because people were not very well informed. Today, there is plenty of work. As I'm speaking to you, I am the sole arbitrator in 12 cases which are going on. They are live. I just came from one hearing to this particular place. Tomorrow is a holiday. Actually, I was told to come tomorrow by Giri, and I refused because I said I require a Sunday to cool off. Because it's not your problems that you're looking at, it is somebody else's problem, and you have to give a solution to that. When I started, they were not, maybe the court cases were in a few lakhs. Over a period of 33 years, today, if you see, I took a count before I came over here. The total number of cases pending in all the courts all across the country are 5 crore 6 lakhs, 5 crore 6 lakhs 40,671 cases. And let me tell you straight away, as Mr. Kamath said, don't ever get involved in the police because the criminal justice system in this country has collapsed. The criminal justice system exists only to give employment to people, not to dispense with justice. That you keep it in mind. The other aspect of law, which is the civil system, exists to provide your hard-earned money to the lawyers. I agree with what you said, Mr. Kamath. Go back in time, William Shakespeare, in his play Henry VIII, third act, says this sentence. The character says this sentence. Let's kill all the lawyers. Let's kill them tonight. And I'm sure most of you listen to music, correct? Have you heard of the group Eagles? Yeah. Yes. Have you heard their album Hell Freezes Over? There is a song, the first song on that CD or that album is Get Over It. And in that, Don Henley sings, Old Billy was right. Let's kill all the lawyers. Let's kill them tonight. You heard that? So you see, criminal justice system has failed. Civil justice system is present to provide money to the lawyers.
Sir, there's
Yeah.
no chance anybody can ever fall asleep in your session.
It's my endeavor not to put you to sleep.
We must have you always after lunch only.
No, that's what happens in IAM for the last 27 years. I've got people who tell me, why don't you speak in the afternoon? Now, next Saturday and Sunday, I'm in IAMK. I'm talking to the senior managers. So my colleagues have promptly pushed me to the afternoon session. Oh, kya hai, sir? आपका तो जवाब ही नहीं, sir. That is all malish and polish for me to vacate the morning session and take the afternoon session. Okay. Now, one of the biggest question that people ask me at various forums Why do you promote alternative dispute redressal? Why do you tell people not to go to the court? I'm not very sure how many of you have gone to the court. The court for me is a sheer waste of time. By the way, I'm a very tough arbitrator. Lawyers hate me. Because what happens in the court is the judge is there, he calls out the cases, the lawyer stands up and just puts his attendance. And after that, about 2 or 3 cases are heard. Out of that one case, the lawyer lifts his ample backside and says, I seek adjournment. And the judge will not even ask this question, why the hell do you want an adjournment? Because the judge's mind is also not on the case. After some time, he'll be transferred. So he's not on the case. So you look at the dates, December is over. Now, February 14th. And why this lawyer is doing this is because he could have taken 20 cases, okay, in a year, and he could have managed it beautifully. But this particular jackass has taken 200 cases. And let me tell you, for just lifting up his ample backside and sitting, the lawyer sends a bill. That's because, I'll tell you, that's because, Mr. Kamath will agree with me, none of you have gone to the court when your case is being heard. The lawyer comes back and says that he killed somebody today. In the sense, I remember once, my client telling me, anybody know, I'll tell you, this is in Tulu, but Tulu. What he fought today, my God, I'll tell you what he fought. I said, that's what he's supposed to do. That means on other days he must have been sleeping, you must have gone, and today he has woken up. So what I feel, like when I do my arbitration, see, my arbitration is very simple. I start at 9:30. I open my, the arbitration center opens at 9:30. I sit inside, parties come, I make them sit down. And first I tell my staff, the Chamber of Commerce staff, you please ask them what they want. Coffee, tea, lemon tea, and biscuits. Biscuits comes automatically. Good day biscuits will be given to you and you get coffee and tea. The persons who come for the first time to the tribunal, they are coffee in the court. I say no, because see, I want you to look at this ADR as something where we are settling a dispute without litigation. I want them to collaborate. I don't want it to be adversarial. I don't want two people fighting with each other and then putting their hands over each other's shoulder and going to the nearest tavern in the evening. That is what lawyers normally do. In the court, they fight it out. They fight it out like two warring dogs protecting the territory. The hackles are raised and this and that and all that. They remind me of politicians. That's why lawyers make very good politicians. You take any politician, BJP or Congress, the first number you get is the opposite party's leader of the opposition or whatever it is, because he needs favors from him. And that fellow needs favors from this chap. So they are all in it together. We are the fools. Sitting on social media and pontificating that, oh my God, this party is good, that party is good. I was just telling the driver when we were coming from Mangalore to here that everybody is a crook. He couldn't but agree. He said, yes, sir, what you are saying is right. Every damn chap is a crook. So, I want to bring about collaboration. I want to bring out a creative solution to their problem. I allow them to select the venue. If they say that my arbitration chambers are not very comfortable, okay, we'll go to a 5-star hotel. We can meet, and in the evening we can wind up in the bar. Not the bar council, the bar of the hotel. But the point is this, what I want to do is, I want to see that these warring parties will go back and do business once again with each other. I want to maintain that friendly relationship between them. They might have had a dispute. What is a dispute? A dispute is nothing but a claim made by one person, which the other person rebuts or does not want to agree. It doesn't mean to say that they are not on talking terms. Many times I have seen, maybe 90% of the cases, when I ask them, do you want to continue doing business with each other? They say, yes. This is a small thing, we want to knock it off. So sometimes what happens is I don't even do arbitration. I just do some sort of a mediation. I sit with them and discuss and talk with them and tell the lawyers, please leave the room. They tell the parties, I want to talk to you all. And then without any problem, they agree. Because it's see, every damn bugger has an ego. No? The ladies also, don't worry. The ladies are a little more friendly. You know, the world is ruled by men, right? Do you know what would have happened if the ladies ruled the world?
A better place. There would have been Cold War.
Nations would not have been in talking terms with each other. So Gaza and Israel would have been like, we're not talking. Men like to go with armaments, this, that, and everything. That's why, ladies don't prefer big cars. Men will have big cars. You go from destination A to destination B. No, you can't. See what happens. The wallet is with the man, no? Ultimately.
The OTP now wallet is in the man, but there's nothing in that wallet.
No, I give OTPs. My husband
So
doesn't
by the
give
way,
OTPs.
by the way, this is husband
I
and
have
wife.
to get the OTP.
I noticed that, but I was just thinking, like, maybe, it could be a coincidence that two people have the same surnames.
There's a third.
दाल में कुछ काला है.
Brother.
Whose?
That's why I'm sitting on top and they're sitting below.
Okay, now, so therefore, you see, when you go for an ADR, the first thing that I like to do is I like to give the parties the autonomy. I don't like to give the lawyer the autonomy. I like to give the parties the autonomy. You select the venue, you select the procedure, you select the arbitrator. It's all up to you. You decide. Because ultimately it's your money. There are times when people come to me and tell me, because in the Chamber of Commerce, we have a very, very, deep discounted fee status, fee structure. God has been kind to me. I don't want to, really make money, but we have kept it very low fees. So when they look at the fees and then they look at the fee that the lawyer is charging them, they decide that we should settle the matter. It happened in one particular case. In the morning, I took an arbitration online. The party was from Pune and we were sitting and doing it in Mangalore. So at 10 o'clock we started online. 4 screens were open. So I was there. The claimant was from Mangalore. The respondents were 2 brothers in a partnership. They were in one window. And there was a lawyer, Pune-based lawyer. From 10 o'clock to 12:15, he spoke 4 sentences. Out of which, if you can count yes as one sentence, it is 4 sentences. In the evening, when I was going for a walk, I normally walk in the evening. I can't get up in the morning at all. So I went for a walk in the evening. I got this buzz on the mobile. I just picked it up. It's that opposite party calling. And I normally don't talk to opposite parties just like that, unless the other party is present. Always it's a con call because everybody should know what we are talking. No, he said, no, sir, I want to talk to you. I said, okay, fine. What is it? He says, I want to settle. I said, in the morning for about 2.5 hours, you are waxing eloquence on why you don't want to settle. And now you call me up and tell me that you want to settle. नहीं सर वो क्या है आपका फीस 12,500 प्लस GST है ना हाँ that is what I'm charging you 12,500 प्लस GST अभी लॉयर का बिल आया सर 50,000 लिखा है उसमें. So I thought it is better because if you call me 4 times, it becomes 2 lakhs of rupees. So I want to settle. So the next day settlement is done, finished, over. That is what I say, give the party the autonomy. Second point I would like to make here is, I don't say it is expensive, but it's faster. I wouldn't say it is cheap, but it is quicker, faster. What happens is, I can tell you that if you do it with me, I will see to it that you get your solution to the problem in less than the number of days which is specified under the Arbitration and Conciliation Act. My shortest case, it took 63 days. Just 63 days. Can you imagine this happening in the court? And in this particular case that I told you, it happened in one hearing. I wouldn't take that as a award. I gave an award in 63 days. This was a settlement. Of course, the settlement can be done into an award afterwards. Normally, in the Arbitration Act, you are given 6 months to decide on the issues. That means a statement of claim, a statement of defense, then you sit and fix the issues. After that, you are given 12 months to give an award, which means it would take 18 months. But I would see to it that it is done in shorter time than that. Because you save time. And time is more precious than money. Yes or no?
Yes.
Yes. I believe time is the most precious commodity, not money. Time is too short. Time is too short even for a long sermon like mine. It should be quick, fast, over, finish. Okay, the next thing, I would say that it is cost effective. I wouldn't say that it is cheap, because you don't have to rush to court every now and then when an arbitration proceeding is going on. Even then, court can intervene, but in very limited matters. That I'll tell you in what matters the court can intervene. But usually the court does not intervene. Normally it doesn't intervene. Having said that, courts do intervene. I have got a stay order on my arbitration in one particular case. The stay order was brought in April of 2022 by the High Court of Karnataka. When? 2022 April. Till now, no hearing has taken place on the issues. Framing of issues itself is taking such a long time. Absolutely, the judge is not even interested. I don't know what's happening, because if you go to the High Court, you are amazed by the inefficiency of the system. I accompanied my client once. My client wanted to go, and one very famous lawyer took us to the High Court. He said, "Banni Nodi, come." My client had filed this appeal in 2018. On the day on which the lawyer fought or talked about the case, he was talking about a case which was filed in 2008. So after the hearing was over, he told me, "Can you imagine when your case will be brought up for hearing?" Okay. But one important caution that I would like to give you, it is not always that you have a resolution. It's not that I'm 90% successful or whatever it is. Sometimes the resolution eludes you. Parties just don't want to settle. They have a grouse, they have a problem, and particularly if it is family disputes. In my 33 years of experience, it has led me to actually believe in the axiom, nearer the blood, the bloodier they are. Family matters, most disgusting. Because what happens is, when you are on your own, brothers and sisters, you don't fight. Your fights are only like, playing and here and there, and he went and told about me, telltale and all that. But once you get older, you marry. For every harmonium, you get a tabla, and for every tabla, you get a harmonium. And the culmination of this is that you get an orchestra. The children come in. Oh, tamki, maraki, sab hai na. So if it's a family dispute, what I do is I bring only those family members to the meeting, okay? And usually that is a little delicate, so we have it at home. At my house, I call them and I make them sit and we talk. My wife will serve some snacks or this one. And no talking loudly and all that, very softly everything is done. And they'll go. My wife will say, "Now wait for their call." Because in 45 minutes, what they have agreed here will be disagreed at home. Because there, the tabla, tamki, mara, everything will start. But just over. So you'll get it. Oh, you know what? What we discussed, I think you put it on hold because, let me tell you, nothing to do with their property. You see, it is this man's father's hard-earned property which they are fighting. I'm amazed, really amazed. And there you can actually see, the wrath of a woman scorned. Because she doesn't agree at all. Because at some function about 20 years ago, they did not come to my house and invite me. So I really avoid this. Now, coming to the processes, you see, we had a beautiful process called Arbitration and Conciliation Act of 1996. It had its fair share of problems, but the government went on repairing it and making it brighter and neater and cleaner. And somebody decided that we should have a mediation act. Parliamentarians and can I remove this? Is this connected to something? I can remove it, yeah, because it comes in the way. I wonder what's hitting me. Yes. It's okay? Fine, perfect. Politicians require quick fix solutions. I remember one anecdote that I had heard. I do not know whether this is true, but this anecdote that I heard, that there was a case of Maya Tyagi. I mean, it's our age maybe, Maya Tyagi. Maya Tyagi was raped. And when she was being taken for medical examination, the cops who were accompanying her raped her again. So this was discussed in the parliament. And now it was decided, with due respect to all the parliamentarians, most of them are nothing in the upper chambers. But they are crooked, they are smart, they have history sheet, they are rowdies, they have passed their law examination without going to the law college, all those types. So they decided that henceforth it is not the woman who should be examined, it should be the man who should be examined. And they're going to bring up an ordinance like that, like this. So the law minister retires to his chamber in the afternoon, he has his sapat and he has a 20-minute snooze. At that time, the secretary comes running, knocks on the door and says, "Sir, there is a problem." "What is the problem?" "The sweeper has said that you raped her." "Impossible." "No, that's what, sir. We will have to send you for medical checkup. And how will we be able to prove that you have not done it? It is the woman who has to be examined to prove that rape has taken place." So you see how their mind works. So everything was going on very well, Arbitration and Conciliation Act. Somebody said that cases are mounting, 3 crores of cases. Now it's come to 5 crores. We should do something. So we brought about a Mediation Act. It was a mediation bill till 2021. This year, September 15th, our president signed it and made it into an act. What they envisaged was that compulsorily you have to go for mediation before you go to court. You can't go to the court otherwise. You have to go what we call as pre-litigation mediation. And this pre-litigation mediation should be finished in 180 days. So we had a letter which came to the Chamber of Commerce to give points as to why we don't agree or why we agree. And I wrote saying that we don't agree. First and foremost, who are the mediators? Not specified. Second, what if I don't want to go for mediation? I want to go directly to the court. Will I not be saving this 180 days? Second, what about the fees? I will have to go through the mediation, pay the fees at various stages, which makes litigation expensive, then climb the courts. So which means to say another further 6 months delay plus a big blow on my pocket. So now what they have said is mediation will not be compulsory, but you have to try pre-litigation mediation. Now they have said 120 days plus another 60 days. And if you don't want it, in 2 sittings you can opt out and then you can go to the court. I'm okay with that. But what they did was, they said that Mediation Act subsumes conciliation which was there in the Arbitration and Conciliation Act. So now you don't have conciliation anymore. Because conciliation is a beautiful thing. All that you have to do was write a nice letter. We call it as an invitation. You name a conciliator and you ask the opposite party, the party with whom you have a dispute, let's conciliate. If in 30 days he ignores or she ignores your invitation, it is understood that conciliation has failed. But otherwise, let's say they are okay with it. They come before you, they come before me. I am the conciliator. I sit with them, I talk to them, collaborative. And then I drive what is called as a settlement agreement. We draft it and all three of us put a signature. The claimant, the respondent, and me, all of us put a signature. They can't opt out after that. Only on the grounds that the signature has been obtained by fraud, misrepresentation, or what shall we say, undue influence or coercion. I have held a gun at his head and asked him to sign. But those things are very, very narrowed out. So this conciliation is working out beautifully. And mind you, in conciliation, I would say, don't bring any lawyers. And it's to work. Now, by one stroke of a pen, they have removed conciliation. They have said conciliation will now come under mediation.
Mediation for which type of cases?
I'll tell you. Mediation is anything that you do under arbitration. Everything cannot go for mediation. Yes. Like, for example, I'll give you the list of what can go for arbitration. The same thing applies. Okay, I'll give you what can't go for arbitration. You're married?
No.
You don't clap.
Yeah. You are lucky. I would say you are lucky.
Getting married soon.
Ah. Yes. No, I don't. I don't. You know, it's like I tell my students, you should get a job. By all means, you should get a job. If you get a good boss, you'll be successful. If you get a bad boss, you'll end up in a startup. I'm not saying about you. You can't. There's like somebody said, no, I don't know who it was who said that if you get a good wife, by all means, enjoy life. If you get a bad one, you become a philosopher. So anybody and everybody talking ill about marriage have a problem. Because it is very well said that, if marriage was so wonderful, God would have got married. Have you ever heard of Mrs. God? You only heard about God, Him, He, Almighty, being superior and all that, no? Have you heard the feminine of it? No. In my religion, we need 2 witnesses when we get married in the church. So I keep telling people, if marriage was so wonderful, you wouldn't need 2 witnesses. Why the hell do you require 2 witnesses? What's going to happen? Yesterday or the day before yesterday, you must have heard thunder and lightning, correct? Huh? Yeah. Marriages are made in heaven, they say, isn't it? So too are thunder and lightning. So by saying that, I wish you all the best. I may not be present at your wedding, but young man, go for it. Okay. So matrimonial matters and divorce proceedings cannot go for arbitration. If you are appointing a guardian for a minor, there's a dispute, you cannot go for arbitration. Similarly, if you are appointing a guardian for a disabled person, you cannot go for arbitration. If it is to do with wills is, I'm talking about not WD and HO wills. You know that? The company that owns the brand Wills is WD and HO Wills. No, ITC is paying a brand fee. WD and HO Wills. Wife daily and husband occasionally Wills. Okay, come back. So wills you can't go because in India wills are disputed. I mean, lot of cases in the courts are pending regarding wills, last will and testament. You do that, no? On what grounds? On the grounds of undue influence. What is undue influence? relation subsisting between two parties is such that one person is or can exercise his will on the other and uses it for an unfair advantage. That is called undue influence. And most of the will cases in the courts are to do with this particular aspect, that is undue influence. So that cannot go to arbitration. Insolvency proceedings cannot go to arbitration. We have the great act called as IBC, Insolvency and Bankruptcy Code 2016, erected only to protect banks, not anybody else. In our year just close by, there was a factory called JBF Petrochemicals that went into insolvency proceedings. The operational creditors got 5.7%. They took a haircut of nearly 94%. And most of them are small and micro and small enterprises. Most of them are washed out. So if you ask me, what is the objective of a law? It is not to protect these people. It was done only to protect the banks. That also because they were Government of India undertakings. You can't go around with 12 lakh crores of NPA. I can't even put the number of zeros to that 12 lakhs. 12 lakh crores. The banks would have been wiped out. Banks wiped out means the government gets wiped out because you have to replenish the capital of the banks. So best is to go into IBC and ask them to take a haircut. So insolvency proceedings, no. Criminal proceedings, definitely no. You steal from somebody's house and you get caught, you say, all right, fine, now we have a dispute, let's go for arbitration. Or you murder somebody and you go for arbitration. And I told you, criminal justice system has completely failed. So you can't go and tell, kya hai sir. Criminal justice system does not agree. We does not mean victory. We means victim. Victim is gone. Fun fact, this Ramalinga Raju? Yes. When he was arrested and he applied for bail, the public prosecutor came in the government vehicle. Ramalinga Raju went to the court with lawyers, 23 lawyers in 23 grand vehicles. So if you are the accused, you have got millions of ways to escape the gallows. But if you are the victim, you are doomed. Because your case is being fought by the court, by the state. And you know how adroit the case, the state is. So understand that. That is why Mr. Kamath said, never get involved in police matters or criminal matters. We can't say you don't kill. Okay. If it is a matter to do with trustees and beneficiaries, that cannot go for arbitration. Competition law does not speak about arbitration. And if it is a dissolution or winding up of a company, there is no question of arbitration. So these things are kept out of alternate dispute redressal. That means it is not according to law. That doesn't mean to say that, you don't intervene in some marital affairs. In the sense, I have got my own students who have had a, live-in relationship and then they did not get married. And when it became acrimonious, they have leaned on my shoulder to help them come out of that, arrangement. Because today, young people don't marry. Young people try to experiment. Let's have a live-in relationship. Their parents have never heard about that, but they are into a live-in relationship. And many of them don't want to have children. Many of them don't want to own a house. Many of them don't want a vehicle. They only want to see the world. And nowadays they adopt pets and they call themselves mom and dad. Haven't you heard that? I went to a house once and she said, I'll introduce you to my son. And I'm waiting for the son to come. And out comes a small dachshund. And I was thinking, now, should I ask them, where is the son? Then I thought, I'm a little wiser nowadays. I've made a lot of mistakes in the past. Nowadays, I say, okay, fine, let's have this. Okay, fine, let's go on. Now, when you come for arbitration, please remember, selection of the arbitrator is the most important thing. See to it that you get an arbitrator who is fair, I mean, fairness means fair. He has some integrity, he's impartial, he knows the subject, and the most important thing, somebody who has command over the language. And language is English. Unfortunately or fortunately, the language of business is English. So therefore, under those circumstances, you should get a person whose one sentence means the same for everybody. Not somebody who writes a sentence and then it means different things to different people. Like, for example, I was an inquiry officer in one case involving an employee of one of those techie companies. So in his leave application, he has written, I require vacation for 2 days, not leave. He has written, I require vacation. Just below that, there's a reason. Now, the reason he has written is, I am going to my village to sell my property along with my wife. Now, you think about it, no? He's not giving you his wife free with the land. He has thought about it in his mother tongue and then translated it into English. ನಾನು ನನ್ನ ಊರಿಗೆ ಹೋಗ್ತೇನೆ to sell my property and my wife is accompanying me. That is what he should have written. But in the local colloquial language, it is, I am going to my village to sell my property along with my wife. So you can't write like that in a judgment, which is an award. You can't. So you require to have good knowledge of it. See, even though I am touch wood, my language is okay. I still use software to see that I don't make mistakes. I fall back on Quillbot, the paid version of Quillbot, and I fall back on the paid version of Grammarly, because I don't want to make mistakes which can be pointed out later saying that this particular sentence means two things. No, it should mean only one thing. Okay.
So before you approach them, how do you know he's a man of integrity?
Make a little bit of it, some investigation is necessary. Some investigation. I'm not saying that you do a deep investigation, but you keep your ears to the ground regarding him or her.
You have a choice when, in one of our cases, the court appointed an arbitrator. Arbitrator was a retired High Court judge, 81-year-old. His teacup used to go like this. 3 years, 543 hearings, 3 years, each hearing 4 to 5 hours. The claimant's car used to go to pick him up, drop him, order passed. After passing the order, within 4-5 months, he passed away. We've challenged the order again, it's gone back to court, and so it's been about 8-9 years since the matter's going on. So when the court appoints the arbitrator, can you choose and bring somebody else in?
No, the problem is no. See, if you are going through the courts have mucked it up totally. The judge sitting there will see to it that his predecessor will get some benefit out of it. So today, if you ask me, the dominance of these judges in arbitration field is killing it. I'll give a very simple case, okay? This was Shapurji Pallunji involving with another party. They are gone for arbitration. Court appointed arbitrator, ex-justice of the Supreme Court. 1.5 crore was the fees. It did not finish within the time. They kept extending because the court started extending. It took 4 years. And the award was given, and within about 15 days, they went back to the court.
Similar.
Yeah. So we have told many times, we have raised this issue with people to be, saying that don't, judges, they go back to making it a court system. Why do you think I don't tolerate lawyers? Because the lawyers make it into a court system. You know, one lawyer comes and tells me, argues with me, he has not given me paginated papers. I said, you damn, put in the numbers now. What's about the page? If you want, I'll give you my copy. Sit there. 20 minutes I'll give you. Get your assistant, put the numbers on the pages. Put 1 here, 1 here, 1, 2 here, 2 here, 3 here, 3 here. What paginated? One lawyer comes to me and tells me, where is the podium for me to argue? So our people are, discussing, Chamber of Commerce, they're flustered with the lawyers. So they say, we should provide. No, I said, why are you providing? We had one old lectern inside, no, where it was all, some peeling off and all that. I called a person and put stickers all around, complete. I put it golden stickers all around and kept it there. If you want, lean on it. This is the problem. See, we have done all this. This problem is people. Okay, come on. Let's proceed. Now, when you have selected this arbitrator, the Arbitration Act says that one sole arbitrator is okay. If you feel that, okay, fine, I need my arbitrator and he needs his arbitrator, then you need to have another arbitrator called the presiding arbitrator. Now, fees are not divided by 3, fees are multiplied by 3. I tell people, okay, sole arbitrator, fine, fantastic. 2 arbitrators, wrong, because you'll get a third arbitrator called the presiding arbitrator. Now you multiply their fees into 3. That makes the entire procedure expensive. And 3 people will not agree on any damn thing. They will not agree. And when it comes to the 3 arbitrators being lawyers, God help us. Because whenever there are 2 lawyers, there are 25 opinions. That you remember. Secondly, what I have found now, there are a lot of scams in these fees, because what has happened in the Arbitration Act, let me share this with you. We have got a Schedule 4. The Schedule 4 is representative of what fees could be charged by the arbitrators. It came in one of the latest, maybe 2015 amendment. Lowest fees is 45,000, highest is 30 lakhs. Arbitrators cannot charge more than that, is what was in the minds of the people who set it out, because they wanted to break this hegemony of the judges. But it was not made compulsory. It was made recommendatory. You get it? Just about August, the Supreme Court ruled that it is not mandatory. It is only recommendatory. Now, what has happened? Some of the judges who have now become arbitrators will charge you, apart from this fee, because they want to say that we are following Schedule 4, they will charge you what is called as reading fee. Just the other day, one very big group here in Mangalore, in Manipal, paid 6 lakhs as reading fee for a document which ran into 120 pages. I told them I would have done it free. 6 lakhs. Then they have sitting fees. Then they have a writing fee. Writing of the award, separate. Then they have travel fee and stay fee. So then your entire arbitration fails, because it becomes expensive and you may go back to court. Got it? Okay. Now, arbitrators will sit according to the act. They have to finish in 6 months the framing of the issues. In 12 months, they have to finish the hearing. And in 12 months, the award comes out. Award has to be signed by a majority, and award has to be reasoned. There should be a reason for the award. Today, you cannot give an award which does not mention the reasons. If there are no reasons, the award is void. In the 1940 Act, that time it was a 1940 Arbitration Act, you could give an award which did not give a reason. You could simply say, Pramod T will pay Mr. Kamath 40 lakhs of rupees, over, signed and given, one sentence. Now, Mr. Kamath will have to rack his brains and find out how this 40 lakhs came about. 40 lakhs kodtare, hege. And then you had to take it to the court and you had to make it into an award, into a decree. Today, nothing of that happens. As soon as I give an award, the opposite party, any aggrieved party, I wouldn't say opposite party, any aggrieved party has got 90 days to challenge it. In 90 days, if they don't challenge it, the award transforms itself into judicial decree. They stop calling it award, they call it as JD. Not Janata Dal, but judgment decree. That is the important thing. Now, I'm not saying that everything is hunky-dory and people will not go to the court. People go to the court. So what has happened over a period of years, the government through legislation has diminished the grounds on which you can challenge the award. Today you can challenge the award if there is fraud and corruption. You can challenge the award if it contravenes Indian law. You can challenge the award if it is disregarding any orders which the court has passed. You can challenge the award if the principles of natural justice have not been followed. That means no notice was given or notice was not served properly. The opposite party or one of the parties did not know that such a event was taking place. And of course, if there is an error in the application of law, that could be grounds for challenging. Otherwise, the grounds for challenging the award are very, very less. Because it cost us a great embarrassment in 2011, which was rectified in 2013 in the Supreme Court. Now, let me give you 10 minutes, I'll finish off. Yes.
Sir, if you challenge.
Huh?
3:55 because 4 o'clock Zoom is coming in.
If you challenge the award on basis of corruption, it will be valid only if you can prove it.
Yeah.
Or like how will you prove it?
Tough. Corruption means the judge or somebody has taken money. And by the way, corruption is rampant. Arbitrators are vitamin. Yes. Now we can finish off in 3 minutes.
Yeah, 4:55 is fine.
Yeah.
Because 4 o'clock that Zoom is coming in. They are already there on the Zoom. So 4 o'clock.
Okay. My problem is people are not aware that there is a thing called as arbitration. People are still placing their faith in the judicial system. That is why the number of cases are increasing, not decreasing. The cases should have decreased, but they're not decreasing, they're increasing. One, I told you, dominance of retired judges. This is posing to be a big problem. I told you about the fees. I have seen court interference myself. Case in point is the High Court stay order on an arbitration, which was given in April 2020. Today, most of the arbitration is lawyer driven, which should not be. Your arbitrator was 81 years old. He wouldn't have used any technology. Not at all. Today's arbitrator will come and tell you, I want a stenographer. Now, where the hell do you get a stenographer from?
He appointed a stenographer, sitting fee, standing fee, everything. He was.
I record it. And today, if you have got fantastic software which can convert your speech into text. I used to earlier use Nuance's Dragon speech recognition software. Now I don't. I dictate it to Microsoft Word itself. It is fantastic. I don't have a problem. 80% accuracy. Because drafting an award, you can't type, with our 2-finger, 3-finger typing. You just talk. 42 watch pages, 60 pages can be done. And the most important thing, I have to drop the bombshell. It is very difficult to enforce the award. You may get an award, but going back to the court to enforce it is another Herculean task. So with this, I am 1 minute before time. Thank you very much and wish you all the best.
Small token of our love and affection to keep it in our office in arbitration. It's one